useful. Just another 30 seconds or so, and then we'll jump right into today's presentation. So thanks for your patience. All right. Well, good afternoon or good morning, wherever you happen to be. Like I said, my name is James Gilmer with Harbor Compliance, and welcome to a very special presentation today on a guide to beneficial ownership information, or BOI reporting, under the Corporate Transparency Act. And I'm so thrilled to see a huge registrant list for today's presentation. I have a suspicion as to why, and we'll cover that today. There's been some impactful updates that I'm sure you're eager to learn more about. So we'll go ahead and dive right in. Um, First, just a quick background on Harbor Compliance. So we are a leading provider of compliance solutions to more than 40,000 clients since 2012. So we help businesses, we help nonprofits from their formation and ongoing compliance needs. And we work very closely with law firms, accounting firms, and other consultants and B2B providers to help their clients meet these various state, federal, and local requirements. And on your screen, you'll see a few of our client logos, a few of our awards. Obviously, today's presentation is about beneficial ownership reporting, but there's one takeaway is we do a lot more than just BOI reporting, and you'll have my contact information at the end if you'd like to learn more about any of those things. All right, today's agenda, this will be a relatively short presentation. Normally these sessions are about 45 or 50 minutes with time for Q&A at the end. We're going to first talk about the major beneficial ownership information update that dropped this past Friday, March 21st. It's a big one. And then we'll talk about the reporting requirements for everybody that's not impacted by that requirement. And then we'll talk about what happens next, because naturally, many of you may have questions following the update that just came out. So we should be able to cover that in 15 or 20 minutes. We'll see where this goes. But if you do have questions as we're talking, please use the chat panel, use the question and answer box. We'll try to respond to those either during the presentation or as time permits at the end. Okay, so first and foremost, what are we even talking about? What is the Corporate Transparency Act? So this was a law passed by Congress in 2021. So I can't believe it. It's been over 4 years since this passed. And the Corporate Transparency Act, or CTA, as we'll refer to it, was intended to enhance transparency in the corporate regulatory framework. Specifically, it was designed to combat illicit financial activities, things like money laundering and terrorism financing, some of the horrible things that bad actors would do through legal entities. And this was a way to shine some light on the beneficiaries, the people, the natural human beings who owned or controlled them. So until recently, this was a sweeping requirement that impacted well over 30 million reporting companies. You can see on the screen what the purpose was. There's a direct quote from FinCEN, Financial Crimes Enforcement Network, which is an agency of the Department of Treasury. And effectively, beneficial ownership reporting was essential in guiding law enforcement, helping our intelligence and security communities quickly identify bad actors behind the companies that were formed in the United States, all in the spirit of combating these illicit and, like I said, horrible things that do happen. As part of this, you're probably well aware, there was a reporting requirement where businesses had to report who their owners were. So they're natural human beings who had more than 25% ownership, being indirect or substantial control over the entity. As of March 21st, so this past Friday, this has changed greatly. This has substantially changed. And the short short summary is that's no longer required for the vast majority of entities. So just to give you some context, in early March, the Department of Treasury sent out a press release indicating that businesses would generally not have to do this if they were based in the United States. They told the public that there would be an update before the deadline of March 21st, 2025. And wasn't technically before, it was in the evening of Friday, the 21st, so after the close of business on the East Coast. But you can see that there's now an alert. This is a screenshot from FinCEN's website that says FinCEN removes beneficial ownership reporting requirements for US companies and US persons, and it sets new deadlines for foreign companies. So this is a massive change, really major update. And you can see a quote that's also listed on FinCEN's website that reads, all entities created in the United States, including those previously known as domestic reporting companies and their beneficial owners, are now exempt from the requirement to report beneficial ownership information, or BOI, to FinCEN. Existing foreign companies that must report their BOI have at least an additional 30 days from the date of publication of the interim final rule. On your screen, you'll have a link to the interim rule. You'll also see the press release that FinCEN put out around the same time. They're pretty easy to find if you were to go to the FinCEN website yourself. So you're probably asking, tell me that in plain English. What does this mean for me? So I'm going to do that. This means that most businesses are now no longer required to report their BOI. This is not a complete surprise. This was hinted at with that Treasury press release that was made earlier in the month. So business entities that are formed in the United States, for example, LLCs, corporations, LPs, LLPs, and so on, generally no longer have to file initial reports along that schedule that FinCEN had been sort of changing around for a little while, and also not required to file any updates or corrections to the federal government if they've already reported. Critically, foreign reporting companies must still report. We're going to cover that in a minute, but that is going to likely be a minority of the people on today's call. Most of the folks on today's presentation, I'm going to guess, either represent US businesses or would really be based here in the United States and wouldn't really have to worry about this moving forward. As of Friday, additionally, FinCEN will not be enforcing any penalties or fines against US citizens or domestic reporting companies or their beneficial owners. This is brand new information, of course, right? So we're about a day and a half since the news broke. It's very understandable that many of you might have additional questions. Quite frankly, we do too. For example, what happens to company information and BOI that was previously submitted to FinCEN if the company had already reported? For the entities that still do report, will the forms, or the filing method, or the information expected change? Will the penalties for foreign reporting companies change? And for everybody, will this requirement come back? As of today's presentation, today's the 25th, FinCEN has not provided clarity on these things at this time. So we're going to continue to monitor the requirements, the changes, if there's anything that's relevant for our clients and partners and attendees, we will we'll be sure to share that. But we do encourage you to keep an eye on this as well. So it looks like we do have a question. US-based foreign companies and jurisdictions are not the foreign companies being referred to here, correct? I'm going to go ahead and answer this one live. So let's talk about who is still required to report, and I'll answer that question at the same time. So in light of this update, in light of the interim final rule, only foreign reporting companies must report. There's a very clear definition. This is also in the FinCEN website about what a foreign reporting company is. A foreign reporting company is an entity that is formed under the law of a foreign country, and it has also registered to do business in the United States or territory or Native American reservation, one of those what we would consider a domestic jurisdiction, and basically registered as an out of country entity. So for example, corporation formed in Ireland and then foreign qualified in New York by filing an application for certificate of authority with the New York State Department of State would generally need to report. Domestic reporting companies, again, are now exempt. So a domestic reporting company is what we might suspect. So if you formed an LLC in Delaware, a corporation in Nevada, that is generally no longer required to report or maintain BOI. Those entities, as we all know, when we're talking about Secretary of State filings, if you register that into another state, that would be considered a foreign registration, but that's not what we're talking about here. In the context of the FinCEN requirement, we're talking only about a company that was formed by the laws, or under the laws, excuse me, of another country, and then has registered that entity to do business with one of the United States or territories. So I hope that answers the question. If you still need more clarification on that, please feel free to reach out to me. Now, if we're looking at the entire population of entities that register in the United States, this is a very, very small subset of all of the entities out there. So again, practically speaking, most of the US businesses that you might have or be responsible for, your clients' entities, as of this time, generally going to be exempt. And so from this point forward in the conversation, we're only going to be talking about the requirements that pertain to these foreign reporting companies. So to be clear, the requirement does exist, but only for a small set of companies here. I just don't want anybody to be confused about why are we still talking about this? I thought it went away. Well, it did for a lot of people, but there are still some groups that this does apply to. So that's what we're going to talk about in the next section, which is those remaining BOI reporting requirements. So again, foreign reporting companies do have to report unless they meet one of the 23 exemptions. I'll show that on the next slide. Foreign reporting companies have deadlines. They still have deadlines, even in light of this initial, interim final rule. And it's twofold. So if there's an existing reporting company, so that company has already registered with one of the states, it has 30 days to report. That would be April 20th, 2025. So coming up pretty quick. For foreign reporting companies that are going to be newly registering in the United States, they're on the clock. They've got 30 days from the time that filing is effective with that state. So if we come back to our example of a Ireland corporation that registers with New York as a foreign entity, they're filing the application for certificate of authority. If that comes back with an effective date of June 1st, 2025, the reporting deadline would be July 1st, 2025, or 30 days from that effective date. There's a additional nuance to this requirement for foreign reporting companies. Those companies are not required to report any US persons as beneficial owners. It remains to be seen what FinCEN will accept on the BOI report. If, for example, that company does not have any non-US beneficial, or excuse me, if that company only has US beneficial owners, what do they put on the filing? That remains to be seen. But nevertheless, that is what the interim final rule proposes. The second part of that is US persons will not be required to report BOI with respect to any such entity for which they are a beneficial owner. So the interim final rule has made it pretty clear that US entities and US persons are exempted from this. Foreign entities, as long as they meet that definition and are not exempt, would still have to report. I'll point out there are some exemptions. These are going to be pretty uncommon. the biggest and most common one has been the large operating company exemption, which, as you can see on your screen, those companies will need to have 20 employees, an operating presence in the United States, and more than $5 million in gross receipts on its taxes. There are other categories that are a lot more nuanced, and they typically deal with organizations that operate in highly regulated verticals, for example, banks, insurance producers, public utilities, tax-exempt nonprofits, organizations that are already disclosing a lot of this information to the government in some other way. So we'll cover really quickly what a beneficial owner is, and this again is in the context of those foreign reporting companies. We're talking about natural persons here, so flesh and blood breathing human beings, just like you or me. And that person or those people need to have either 25% indirect or direct ownership over the entity's interests, or they exercise substantial control. And substantial control, as you can see on the screen, has a number of components to it. Generally has decision-making authority, or senior officers of the company, and sort of as a catch-all statement, they're calling the shots within the business. So it's pretty clear for a lot of organizations who those people are. If that is unclear within your own organization, we'd invite you to speak with your general counsel or attorney or somebody who can interpret that for you. And when we're talking again about these foreign reporting companies, they will still have to file, at least based on what we know today, multiple types of reports. First and foremost, that initial report, which is going to be due within 30 days of registration, or of course, if they're already registered before April 20th, they will have to continue to maintain BOI, which is a really important component of this. So if there's any changes to previously reported information, they will have to submit that to the government within 30 days, as well as any corrections if there was a good faith error, which does happen. We're all human. FinCEN does require still an update to be made within 30 days of that inaccuracy being identified. So again, this is all for your foreign companies. Domestic entities, for now, you don't have to do this. For those entities that do have to report, there's really two ways. You can file directly through FinCEN. Here's the link where you can do that. There's no cost to file directly with the government. Second option, we are a service provider. We provide a managed solution that securely stores and tracks BOI. We handle all the filings on your or your client's behalf. So if you do want professional help with that, you can reach out to us. There's no obligation, of course, to use us. But like I said, if you come to the point where you realize you need to report, it's definitely important that you do so, either through the government or if you do want our help, let us know. Based on what we know today, penalties for foreign reporting companies are unchanged. So penalties that can exceed $500 a day, criminal penalties, these are still, as far as we're aware, in play. Of course, we'll keep an eye on this, but for those entities that are impacted by this, it's definitely important to meet the requirement and file on time. Okay, so what happens next? Love this question, right? So many legal experts, if you've been following this, expected the CTA to stick around over the last 6 or 8 months in particular. There's been plenty of legal challenges and legislation, and the CTA has stuck around and survived them all. So, from our perspective, this is something that, it's not entirely surprising, but we've learned not to get too high or too low on news like this. I'm sure there's people listening in who are thrilled that this is not a requirement right now. Maybe there's some that are disappointed. Regardless, regulation is a dynamic landscape. And so we would recommend that businesses and their advisors continue to monitor the federal requirement. Any future relevant updates, certainly we are with 40,000 clients and partners who really trust us to be keeping track of this and handling this for their clients. we're doing our utmost to stay on top of this, which is why we do sessions like this. The other thing for you to keep an eye out for are state level transparency initiatives. So very similar in concept to this federal requirement, but just at the state level. For example, the LLC Transparency Act in New York, which was passed and signed, I believe, at the end of 2023. And this could indicate a trend of the federal government continuing to push these requirements down to the states. Many of the legal experts in our network do believe that transparency is here to stay. In what form? Hard to say. We're not going to speculate on this call, but you should be aware that there are multiple state level initiatives like this, something that we're keeping an eye on, and you should too. And of course, there's always the question, as I posed earlier, will the federal reporting requirement come back at some point in this form or another? That remains to be seen. So we're taking the news as what it is, and we'll continue to take next steps together. So for those of you who are on the call who may be clients or prospective clients of Harbor Compliance, just a quick update for you. So as we talked about at the beginning of the presentation, we are more than just a BOI reporting service company. I know there are some competitors out there who are just that, but we do a lot more. And that's by design. We are well positioned to help you, your business, your nonprofit, or your clients with any variety of business or registration services. Our SOC 2 compliant technology stores information, we automate filings, and there's a real reason why we're the multi-state and multi-entity compliance provider of choice for 40,000 clients. So just because this particular requirement has gone away doesn't mean it won't come back, and it certainly doesn't mean we can't help you with many, many other things. So I would still invite you to reach out to us if you have a business, if you have a nonprofit or clients of your own, to learn more about our capabilities and how we might be able to help you. Of course, if you are a client specifically of our beneficial ownership reporting service, please be on the lookout for additional updates directly to you about your services. We will be in touch to make sure that you have the answers that you'd be looking for on that side of things. Okay, so I see a few additional questions coming in, so I appreciate that. Keep them coming. This is the conclusion of the bulk of the presentation. I've got my name and email on the screen, so if there's something that you'd like clarification on personally, please reach out. In the meantime, I'm going to go ahead and turn my attention to what's coming in to the Q&A panel here. So give me a minute just to unpack these. Okay, so the first question, will you be sending PowerPoint slides and forms required? You'll be getting a copy of the presentation after the session. So just look into your, I guess it'll be the email that you used to sign up for this presentation. So that should come out within 24 hours. Let's see, we answered the second question about foreign companies. Here's one. If a company is owned by a foreign owner, i.e. someone in Ireland, but the company was registered in the US as they a foreign entity, I assume that means are they a foreign entity? So per the interim final rule, a company that was formed in the US, so for example, incorporated in Delaware or organized in Pennsylvania, generally those would be exempt under this rule. Doesn't matter who the owners are. If the entity is formed here domestically, it's exempt. If the entity itself is formed by the laws of another country and then registers here through the process of foreign qualification, then generally it would need to report. So it depends on the situation, but again, generally the domestic entities here no longer have to report under this. Okay, next question. Is there a reason as a small business owner that I should complete a BOIR with it being voluntary? Does it protect my business to have this? Well, that's based on a little bit of old information here. It's no longer voluntary, it's just not required at all. That's that's the rule at this point. So there's no further opinion I can give on, whether or not you would benefit from doing that voluntarily. It's just not a requirement anymore. Okay, so we have a couple of other questions in here. I want to open a general federal company, but I'm not a US citizen. What challenges would face me? Well, if you're looking to form a business in the United States, businesses are not formed at the federal level, they're formed at the state level. So we would start there. So if you are interested in our business formation services, please send me an email. I'd be happy to connect you with a member of our team, send you some more information about selecting your entity, selecting the state, and what our scope of services and fees would be to set up your US entity. Of course, based on what we've been talking about today, entities that are formed in the United States will no longer have to report their BOI. So if anything, that's one less step that you'll have to take. Okay, next question. Do you recommend submitting the report for US companies regardless? It is not mandatory. I'm not in a position to answer that. Like I said, the interim final rule says that this is no longer required. The business can make its own decisions with respect to that. It is a public filing portal. Presumably, all entities can still file, but we're not in a position to advise or recommend whether a given business submit the report. All we're here to do is communicate that it's no longer required. Okay, we've got the last question. Is this something that with the next president could get changed as the BOI was created under Biden's presidency? Yes, is the short answer. This Treasury update, as far as I'm aware, was a decision by the current administration. So trying to remain apolitical here. But yeah, theoretically, a new administration, new regime could make changes that revert this, or something different could happen down the line, whether that's legislative or executive or something else. So we're not here to speculate. As I've talked about throughout the presentation, this is the update as it stands today. So the vast majority of domestic entities do not need to report. I know that's welcome news to a lot of people. But like I said, we're not getting too high or too low on it either, because again, it could always change. So what we would again recommend, monitor the requirements on your own, make sure that you are subscribing to our email lists, to our YouTube channel. I know this is being live streamed right now. Make sure that you're in the loop, because we're monitoring as well. And like I said, if there are any other ways that we might be able to help your organization, your firm, my information's on the screen there. I would welcome a conversation at any point. This is very clearly a dynamic landscape. Bit of relief, as we've been talking about today, for a lot of businesses that have been waiting with bated breath and hoping for this. But there's certainly other complexity that we can simplify for you, and we're here whenever you're ready to have that conversation. So with that, I think we've gotten to all the questions. I want to thank everybody for your time. Really great discussion. We'll wrap here. And like I said, if you do have any questions today or tomorrow or in the future, you're welcome to reach out to me anytime. All right, thanks, and have a